SJC-12737, NTV Management, Inc., and others, v. Lightship Global Ventures, LLC, and others.
Mr. Marks, good morning.
Good morning. May it please the court. Daniel Marks for the plaintiff appellant NTV Management. After a week-long trial at which Kent Plunkett testified, the jury unanimously concluded that both Lightship and Plunkett engaged in unfair and deceptive trade practices against NTV and awarded nearly $1 million in damages. The trial judge, Judge Liebensberger, ruled that the evidence at trial amply supported that jury verdict. For several reasons, LGV and Plunkett should not be permitted at this point to escape all responsibility for their willful violations of Chapter 93A by complaining about NTV's failure to register as a securities broker under Chapter 110A. I'd just like to start by summarizing the three main reasons why that's the case. First, Chapter 110A does not even apply in this case where NTV did not agree to broker securities. Second, even if Chapter 110A did apply here, it would only bar NTV's contract claims, not its independent 93A claims. The broker registration rules do not immunize bad actors like LGV and Plunkett from all statutory and tort liability. Finally, even if Chapter 110A were to bar all of NTV's claims against LGV, Plunkett, as a co-defendant, cannot hide behind Section 410F because he was not even a party to the contract between NTV and LGV, and the jury found that Plunkett personally should be held liable for his unethical and deceitful conduct.
I guess the big issue here is how we define securities.
That's certainly one big issue. Yes, Your Honor.
And what do we make of the contractual provision about financing? That seems to be what Judge Liebensberger really focused on, the financing component of it. How does that interplay with the definition of security?
Right. So I think the best argument that LGV has, and certainly something that Judge Liebensberger looked to, is this notion of financing, right? And I think the implication of that is that any financing necessarily involves securities. But we know that's not the case. We know that's not the case for a number of reasons. Number one is that the U.S. Supreme Court has said that's not the case. That's Marine Bank. Marine Bank involved in equity financing. And the Supreme Court said that's not a securities case. The federal securities laws do not apply. And again.
But I thought investment contracts are deemed securities under, is that right?
They are, Your Honor. So the Howey case, and there's a long line of authority, right?
But isn't this an investment contract?
No. And here's one of the problems, Justice Gaffer. We don't know what this is, right? Lightship and Plunkett don't put in any evidence to describe how this financing is actually going to happen. There are references in the contract to equity or debt, but there's no evidence about how the financing happens. We don't know what the nature of a possible investment contract might be. So, for example, and this is what Justice Stevens is talking about in his dissent in Marine Bank, or may have been Landreth, the law provides almost infinite flexibility and provides for creativity. And the reason why there are giant corporate law departments at places like Mintz-Levin is so parties can contract around tax implications, accounting implications, securities implications, and they can do that by structuring deals in different ways. This deal was structured as an asset sale. Things can be structured by having an LLC be the acquisition entity, and membership shares or units in an LLC wouldn't be securities. It can be done as a partnership. It can be done with one fund acquiring the entire.
But does that require us to look to what actually happened or to the contract itself?
The contract. So here the contract is ambiguous. It contains stray references to equity or debt financing, which alone do not make clear that this is a securities.
So it's ambiguous. You said language in the contract is ambiguous.
That's right.
And so how do we interpret the contract then? Because that's what we're doing. We have to interpret the contract, not what you did.
Right. Exactly.
We
right.
agree with that.
100%. That's Indus Partners, right? So now it's the burden of LGV to establish its entitlement to this protection in 410F. So they have to.
But what's ambiguous about it? I'm just looking at the actual language.
Yep.
Financing, NTV will endeavor to source capital and structure financing transactions from agreed upon target investors and/or lenders. NTV will facilitate and participate in meetings and due diligence with capital sources, structuring and negotiating terms and closing financing. That's not an asset, that's purchase, it's an investment.
Oh, it's absolutely an asset purchase, and I think there's explicit language in the contract that makes that clear. The reference to capital sources and financing, the question is that enough to make this subject to federal and state securities law? And I'd say cases like Marine Bank make clear it doesn't necessarily stretch that far. The other issue here is that there's no suggestion as to how this is actually going to ultimately happen. So you look at a case like Indus Partners, or you look at a case like Novellos. Those contracts between the unregistered broker or consultant and the company being sold explicitly talk about the sale of securities. Novellos is a private offering of securities. So in Indus Partners, the transaction fee is based on the share price at which the company gets sold for. There's nothing like that in this contract. This contract just says, help us to raise money without specifying in what form in order to buy back a piece of a company from IBM. That is not enough to make this a securities transaction which triggers all of the implications. Remember, we're not just talking about broker registration. That then implicates all of the requirements of federal and state securities law.
Step back. Whose burden is this?
Oh, it's clearly Lightship and Plunkett's burden.
Because they're trying to invalidate the contract.
Absolutely, Your Honor.
How maybe this doesn't have anything to do with our decision. I don't understand how there's a jury trial and then we're resolving this legal issue with all this money and all this time, litigation time. Something went wrong procedurally here.
That's a hard question, Your Honor. I wasn't trial counsel, so I'm not really in a position to say. I have sort of some of the same questions about the procedure which is unfolded, but I think for our purposes today, where that leaves us is we did have a jury trial. We had a jury trial in which all the principals testified. We had a jury trial in which a jury looked at all the evidence, heard the testimony, and said, Ken Plunkett and Lightship engaged in unethical and deceptive practices. And then Judge Liebensberger, after that, said, I'll deny a post-trial motion. I think the evidence supports that finding. Treble damages in this case, willful violations of Chapter 93A. Now there's no motion for reconsideration. There's no cross appeal of that. So the factual world that we're living in is a world in which the parties on the other side of the V have engaged in unfair and deceptive practices, willfully. And the question is whether or not a technical violation, a harmless technical violation of a broker registration rule should be enough to wipe out that jury verdict and to say, no, you don't have to pay that $1 million. In fact, you're not liable at all anymore. And I think it's important to keep in mind, we're not talking about an unlicensed stockbroker selling retail securities to mom and pop investors. This was a bespoke private transaction, heavily negotiated on both sides, in which the investors ultimately were HIG Capital, a $30 billion investment fund, and Prudential Securities, a massive financial institution. There's no risk that these entities are going to be taken advantage of by an unscrupulous, unregistered stockbroker in the kinds of cases that the MSD has said it is rightfully concerned about.
But how does that, I mean, assume you're right, how does that help you? Because the statute is the statute. The statute doesn't necessarily provide equitable alternatives.
Okay, I want to say two things about that. I'm going to try to remember both of them. First of all, this case, it's very tempting to talk about the statute and to think only about Chapter 110A and particularly 410F. But this case is about two statutes. This case is not just about Chapter 110A, it's also about Chapter 93A. So yes, there's a tension there, there's a balance, and the question is, are we going to prioritize as a policy matter scrupulous compliance with technical registration requirements, even at the expense of allowing people to get away without any liability for willful violations of Chapter 93A, when a jury has found that they've done that. So that's one thing. But let me directly answer your question about the statute. And see, I did exactly what I was going to do. I forgot what my second point was. I promised myself I wouldn't do that.
You should
Your Honor,
always write
please
them down.
indulge me and ask the question again, Your Honor.
The question, I do remember the question.
forgotten it, too.
I do remember the question. The question
makes me
was,
feel slightly better.
assume you are correct about the equities, that this is not the type of case where
Yes.
we would generally worry about it, but we still have the language of the statute, which the federal statute says shall be void, and you say voidable, so let's assume it's voidable since they want to void it. And then the other one says may base any suit in the contract. I mean, we're stuck with the language of the statute in terms of what it says. So how does, I mean, I understand the separate argument that even if the contract itself is void, it doesn't give you a license to engage in a scheme to engage in an unfair and deceptive practice. But put that aside for a moment. How does this help you on the contract side?
Okay. Now I remember my answer, so I'm glad. Thank you. So this is ultimately a statutory interpretation question, right? So it comes presented as a contract case, but really the question presented for the court is one of statutory interpretation. The question is, what does the phrase "based on the contract" mean in 410F, right? And the question is whether that means only suits to enforce a contract or to vindicate some right in a contract, or does it mean more broadly any suit, whether it's contract, whether it's tort, whether it's statutory, that relates in some way to the contract? Our position is that it has to be read consistent with its plain meaning, because there's no statutory definition. Based on the contract means you're suing to enforce the contract. So we're talking contract claims, implied covenant claims, quasi-contract claims. We're not talking about tort claims. We're not talking about 93A claims, even if they relate somehow to the contract. And that's the consensus in every single state Supreme Court in a blue sky law case that has ruled on this question. And it's also consistent with the legislative history of the Uniform Securities Act, which is the basis of our state law, that when the courts talk about prohibiting a contract based on, prohibiting suit based on a contract in violation of broker registration rules, they mean you can't sue for breach or something akin to breach. But a Chapter 93A claim...
They don't have an arising out of language similar to the insurance world where we look to see whether something arises out of. I mean, it just seems hard to say there's a duty here that doesn't arise out of or is based on the contract, isn't it?
Well, first of all, the simple answer is no. The statutory language is based on, right? So, and there's a whole body of case law that we cite in the briefs about what that means.
What's a good case, just so we can look at it, that makes your point that based on is not what Judge Leesberger found here?
So,
which case should we look at?
So I think the cases that you can look at a few of them. The cases that the parties talk about that's probably most fruitful to look about are the two cases about Girdwood. One's called Girdwood, and then there's litigation a couple years later by Comsalt. It's the same parties. They end up in court a lot against each other. But there the court articulates the principle that based on the contract means, quote, enforce the contract to vindicate a right granted by the contract. And it also, I think, gives this kind of helpful explanation, which is if the source of the cause of action, the source of law on which you're suing, comes from something other than contract law. In other words, if I don't need to cite my contract in order to win, then you're not suing to enforce the contract. You're not suing based on the contract.
All right, I might have missed this. Aren't you saying in the 93A claim that you were induced into entering this contract because they were using your client as a stalking horse? They're trying to get action out there when they already know what they're going to do and they're trying to get more money? Absolutely,
and it's a great question, and it's the second piece of the answer to Justice Kaffer's question. The first piece is the question about how we're defining based on the contract. But here the facts of the case, as found by the jury, are that there is bad conduct. There's violative conduct under 93A before there's even a contract. And then during the whole period of the contract, once Ken Plunkett's already decided, in his words, NTV has failed, it will not succeed, and he never intends to pay them, he continues to use them over the course of months as a stalking horse. This is the evidence at trial, all of which needs to be looked at in the light most favorable to NTV at this point. So you're absolutely right. Even if we were to say all of the bad conduct that's a 93A violation during the period of the contract is covered, we still have all this bad conduct. There's lies about whether this deal with Stifel, another investment banker, was exclusive or had been terminated. There's lies about whether or not the IBM opportunity was exclusive or not. None of this is denied. On appeal, their argument is, well, you didn't pursue your fraud claim. But this court knows, and has said in many decisions, that you don't need to establish fraud in order to win under 93A. You don't need to show things like reliance and intent to deceive, which is exactly what the judge charged the jury below. So you're right. And if you look at cases like Jacobson, right, it's a nice parallel. There's really no spot-on authority, Justice Kaffer, for this Section 410F question here in Massachusetts, but there are parallels. Cases where we look at, say, does a forum selection clause apply to a 93A violation? And there, cases like Jacobson say, Well, hold on a second. If you're talking about pre-contract misconduct, pre-contract misrepresentations, how can that possibly be tied up in a limitation of liability or a forum selection clause or a choice of law provision in the contract? You were doing bad stuff before there was a contract even in existence.
One last question. You're not asking us to provide any award based on quantum merit or unjust enrichment?
No, Your Honor.
So you're going for broke as to the contract and for the 93A?
The 93A treble damages, but just to be clear about this, even if this court were to find that somehow 410F protects Lightship as the contracting party, it can't possibly protect Kent Plunkett, who is not a member, not a party to that, and that's Standard Register. Standard Register says, now hold on a second, just because you're a corporate official, our law says you can be held accountable for your misconduct. It doesn't say you can hide behind contract terms the company negotiated unless you sign that contract. He didn't, and so he's not entitled to its protection.
All right, thank you.
Thank you, Your Honors.
Mr. Hammerline?
May it please the court, good morning. My name is Joseph Hamline. I represent the defendants, Lightship Global Ventures and Kent Plunkett in this matter. So to pick up where Mr. Marks left off with respect to a couple of these points, they're addressed in our brief. Some of them are addressed in our brief. But in particular with respect to the securities issue, I should note that in their opening brief, they relied entirely on the argument that the only thing that they were contracted to do under the agreement was to advise on an asset acquisition. And
Is that their
that's,
appellate brief are you talking about?
What's that?
Is that their appellate brief or their
that's
trial
their
brief?
appellate brief,
Okay.
their opening brief. We then cited, as Justice Caffer was, we cited the actual language of the contract where it says that in fact they were retained to source capital, both debt and equity, for the financing for the acquisition of these assets, and that's what they were retained to do. So in their reply brief, they did a 180, which they did on just about every issue between the trial and the appeal. They did a 180 and walked away from that argument and addressed the argument that we just heard, which is what they were retained to do. They were not retained to source securities. They were retained to raise financing in some other fashion. They refer to Marine
I
Bank,
get
which
you
is
on-
a CD case.
I get you on that, and I'm interpreting the language. What I'm trying to understand is, there's a lot of federal law on this that's not crystal clear, particularly this distinction between facilitators and brokers. Also not really briefed here, but I'm trying to make sure I understand when you become a broker in sort of when we're dealing with sophisticated entities like we are here. And help me understand that a little bit, because
Sure. The other thing I was going to say, which I think gets to your point, is that when we briefed this before Judge Liebensberger, we briefed all of the factors that are listed in like the SEC versus Zubkis case or the Novellus case, which is Judge Fabricant's case, a copy of which is attached to the Securities Division's brief, where they cite the factors which make someone a broker-dealer, and they basically pull those out of the regulations.
and what-
NTV did not raise any of those issues on appeal here. Their sole issue here was with respect to, is this a security? If it is a security, then I think they admit they're a broker-dealer because they haven't questioned any of that analysis that Judge Liebensberger did, in particular under the Indus Partners, which I think stands for Industry Partners, although I've gotten so used to calling it Indus Partners because that's the way it's cited. But Justice Caffer, I don't know if that answers your question, but
well,
that's...
I'm just trying to make sure that our case law is clear on this. So when we look at these two cases that you're talking about, affecting transactions, my understanding is solicitation of investors to purchase securities, involvement in negotiations between the issuer and the investor, and receipt of a transaction-based compensation. Are those the factors discussed?
Those are the factors, yes.
So those are the primary factors.
Those are the primary factors. In our trial court brief, I referred to those as the 6 factors. In various cases, there are 10 or 12, but I think they distill down to 6, which are, I think, listed in the Novellus and the SEC versus Zubkis case. Notably, those are not raised in any way in NTV's appeal. Their only issue they raised in their opening brief that we responded to was that they were only retained to work on an asset transaction. And we quickly debunked that.
Can I ask you a question about
Yes.
your evidence? Was there evidence as to these factors at trial, or was this only something that went to develop before Judge Liebensberger?
There was a lot of evidence at trial. It was a week-long trial.
In terms of the factors that
About
you were
the
just talking?
factors.
Was
terms
there
of the
evidence
factors.
factors? Did you offer evidence as to that?
We didn't address those particularly, but we did ask questions, and there was testimony by Mr. Whalen in particular.
Yeah, but you stipulated that the only evidence that necessary to decide this issue was the face of the contract.
That was Judge Liebensberger's position. I said, basically,
But
that's,
that's what's before us.
I'm sorry?
That's what's before us now. It's just the face of the contract, correct? And the scope of the work?
Well, Judge Liebensberger also listened to all of the evidence, and I don't think there's any way he
But he
could.
decided it based on the language of the 2 words in the scope of work, right?
I think more than 2 words, but yes, he
Well,
said he decided
sorry,
it
6.
based on the contract.
So I guess the question I've got for you is, what kind of chaos would this cause to the acquisition of small businesses and closely held corporations?
None. The Landreth Timber versus Landreth case, a U.S. Supreme Court case, has addressed this issue of asset acquisitions, and it held that even where there's an asset acquisition, in that case it was a lumber mill, and a group bought that from the owners, and that group that bought it was going to have the owners run it. They bought the stock. They argued that that was an asset acquisition, did not implicate the securities laws. The Supreme Court held that as long as stock was being transferred, it doesn't matter. It's a securities transaction.
So is it your argument that if Lightship had known that they had contracted with somebody who was not a broker-dealer, that they could freely engage in unfair and deceptive practices without having to worry about liability?
No, that is not our position, Your Honor.
Isn't that the outcome that would be asking us to
No, what I'm asking is for the statute to be applied in this case.
stand? But I mean, let's assume you prevail on the contract side.
Yep.
Plunkett was not a party to the contract, correct?
The way they argued the case at trial, they argued to the jury that he was the alter ego.
But the special verdict form with regard to the contract claims are only against Lightship. They're not against Plunkett,
Yeah,
correct?
but I'm not sure that's the relevant inquiry on that issue, Your Honor. I think the relevant inquiry is, as the Securities Division stated in its brief, was the decision based in any way on any purported right under the contract. And the rights and obligations under the contract were the essence of the case presented by NTV through the entire case.
But why is Plunkett allowed to engage in unfair and deceptive practice? Simply because he was doing it with somebody who should have?
Because if we had
Pretty sure it's
tried this
broker-dealer.
case without the contract, NTV would not have any of the arguments they submitted with respect to the 93A violations, which were that this was a contract where $330,000 was owed, that's purely under the contract, that this was a make them sue us to get paid and chisel us down in a post-work settlement. None of that can occur if there isn't a contract here. All of it's based on the contract.
Your view is that the language essentially should be read as that you're denied any damages that have any relation to or are in connection to a contract?
No, if the 93A claim is based on the contract, any purported right in the contract, and that's exactly what they argued. They argued in their opening and closing that Mr. Plunkett breached the contract. Their argument was that the 93A violation was the failure to pay the $330,000.
But I mean, but.
That's clearly under the
I've
contract.
looked at the special verdict. There's question one is, did he breach? Question two was there a breach of the implied covenant? Only against Lightship, both contract-related claims. And then the answer is, if you answer no to 1 and 2, then go on to answer the 93A. So why does that mean that 93A is not independent of the finding of breach or implied, or breach of the implied
I
covenant?
think the analysis for the purposes of the broker-dealer statute is if you can't base your claim on any of the rights or obligations in the contract, they don't have a 93A case to present. Their entire case under 93A was the contract
But you didn't
and the
object-
failure
you-
to pay.
You did not object to the special verdict form, which expressly says you can find no breach of the implied covenant, and yet also find a 93A violation.
We had also agreed that the issue with respect to the contract was going to be heard after this, and we weren't going to raise those issues during the trial.
Okay, but try my question. You did not object to the jury instructions, which said that you can find no breach of contract, no breach of the implied warranty, and yet you can still find a breach of 93A.
I did not, Your Honor. My understanding at that time was that since the entire case was based on the contract issue, that if, as the Novellus case and as the Securities Division states, that any suit that is based upon any purported right under the unlawful contract cannot be enforced or is void.
The contract is void. It doesn't say anything at all about the 93A claim.
Contract is void.
Yeah, but so
But you
what?
can't make the claim to assert the 93A claim here if the contract is void.
I'm not sure I agree with that.
But if the contract is void, how can the $330,000
The conduct.
be
It is
relevant?
the conduct.
The conduct is failure to pay the $330,000.
Acting in an unfair and deceptive manner is the conduct.
It's the conduct is based on the contract provision. Without the contract provision, there's no claim. The entire argument, every argument in the opening and the closing and in the briefs.
Meaning that, whatever this guy's name is, can do whatever he can string these people along as long as they don't have any kind of duty to him arising out of their business relationship.
Here's the analogy, I think, that works better than that, Your Honor, is if you're selling a house and a broker comes to you and you don't have an agreement with that broker, but they want to sell the house and they want to schedule appointments with you, you have no duty to do that. You have no duty to pay them a commission.
Well, let's take it even further. So we don't like people selling houses unless they're licensed real estate
Correct.
brokers. Is that your even better argument, that if we've got some guy out there outside of the industry behaving improperly, even if he's behaving improperly, we don't want him in the business of selling houses? Is that your argument or no?
My argument is,
'Cause I
I think that's a better twist or better additional point on the analogy. But yes, I think the issue there is if there's no contract, then there's no obligation to do any of the things they said that Mr. Plunkett didn't do.
What if
Well,
Mr. Plunkett,
is it that there's no contract, or that we don't want, whether this guy's a broker or not, separate question, but we don't want people out there engaging in this business if they don't get a license? I mean, to me, that seems to be your better argument than it's based on the, I mean, it's based on the contract, but it's also that the purpose of the statute is to keep these guys out of this.
Yes, I agree with that, Your Honor.
So, taking the Justice Kafka analogy, if somebody who's not a licensed realtor is trying to sell you a house, you could get them to do a whole lot of work and not pay them a penny?
It's,
And have
the analogy
no
here is
recourse?
that they wanted to schedule meetings with people. That broker might want to schedule meetings with you. You don't have to take those meetings. That's not a 93A violation without a contract. And you don't have to pay that person a commission if that person doesn't bring a purchaser to the table.
well,
And
how
here,
about this? How about this? Say that Mr. Plunkett knows that, that he's not a broker, that he knows that he can't be engaged in this, dealing with securities. But he says, well, geez, this guy knows a lot of people. I'll have him keep on bringing me people. And lo and behold, yeah, he brings the person to the table that strikes the deal. And he would have got millions of dollars, and he's been working it for 6-9 months, great contacts, and that's why they have a deal. And then Mr. Plunkett sits back and says, well, geez, this is great. I knew all along I wouldn't have to pay the commission.
I think that's a step beyond the hypothetical that we have
I'm just
here.
curious what that case is, because then there's a 93A claim, and the contract would have been an illegal contract. What's the result of that case?
It's a quantum merit claim under an illegal contract, which I don't think under the Novellus case and the other cases that we've cited, they can recover.
So no cause of action.
No cause of action, correct. I think that's the purpose, but otherwise you're doing an end around these
But
licensing requirements.
Well, I mean, but Congress and the legislature know there's many alternatives in terms of the phrasing of it. But here they phrase it to the contract is void in the Congress, and the legislature that they phrase it that you may not base any suit. You're asking us essentially to say that you may not be awarded any damages in connection with any contract.
No, I'm following along with the language in Novellus and the Mass Securities Division, which says that any suit based upon any purported right under the unlawful contract can't be the basis for the 93A or the quantum merit or other claim.
So if they had not brought any claim against Lightship, but brought it only against Plunkett and only claiming 93A, you would say they'd still be out of luck?
Well, in fact, the claim against Mr. Plunkett in the trial was based on the contract. Repeatedly, they say,
Try my question. Let's assume there was only one, let's assume there was one defendant, Plunkett, and one claim, 93A.
yeah, so long as
Win?
they did what they did in this case, which is base all of their arguments on the contract, no, they don't win, because that's using a purported right under the contract to assert a claim under 93A. I mean, they argued in their opening and closing, Mr. Plunkett breached the contract. Mr. Plunkett didn't honor his requirements, his obligations under the contract. Mr. Plunkett didn't do the things that he needed to do under the contract.
Wasn't a party to the contract, right? He wasn't a party to the contract.
But they're also saying that he was the alter ego of the company. So that's why they're making the argument.
Okay, thank you.
Since we didn't get to respond to their argument that this is not a security, can I just add 2 points on that?
Wasn't that the whole subject of the brief?
We didn't get to reply to their brief. We replied to their brief that said that this was only an asset acquisition under the contract. And we replied to that saying, no, there's language in the contract that said that this was sourcing capital for a debt or equity acquisition, including warrants, and then they went out and solicited VC and PE funds, and in the PowerPoint that they distributed, which is LGA 70 to 74, particularly on 74, they talk about dividends and an IPO and the kinds of things that are, you know, uniquely kind of relevant to securities. And this, if you look at the Landreth Timber and Landreth case, talking about what is a security, it's an investment in a common enterprise with the expectation of a profit. That's exactly what was going on here, which harkens back to the investment contract issue. And they were looking for dividends, they were looking for a possible IPO, they were sourcing debt and equity, which are both securities.
Okay, thank you.
All right, thank you.